Is it a complicated process to switch to a new firm in the middle of a case?
Well, it really depends on what stage your case is in. For example, if you're in the middle of a trial, you would probably be well advised not to switch. I'm not even sure the judge would allow you to do that in the middle of a trial. But the earlier stages of a case, it's certainly an option the client has to switch attorneys. In our line of work, in personal injury cases, we take cases on a contingent fee basis, which means that our fee is a percentage of whatever we're able to obtain for the client at the end of the case. And a lot of clients wrongfully believe that if they fire their lawyer who they've signed a contingency fee agreement with in the middle of the case, that they'll have to pay them at the middle of the case, or they'll have to pay double at the end of the case. And that's simply not true. When that happens, when a client decides that they want to change lawyers, say at some point before trial, their first lawyer can place a lien on the file, which means he just notifies the defendant that, hey, at the end of the case, I need to be compensated for the work I've done. And then the new lawyer and the old lawyer have to get together and work out what portion of the contingency fee goes to the old lawyer, what portion goes to the new lawyer. And if they can't work it out, then the court will get involved and work it out for them. But the client is not paying extra by changing lawyers in the middle of the case, nor are they required to pay their first lawyer if they decide to change lawyers in the middle of the case.